Hi, this is Lee from the Law School Toolbox. This series is designed for incoming 1Ls, students who are getting ready for law school and want a head start on the law they're about to spend the next year learning. Each episode in this series will give you a simplified overview of one of the core 1L subjects. We're not going to cover every doctrine, every exception, or every nuance. The goal is to give you the framework so that when you walk into class on day one, you already have the mental shelves to put the new material on. Now, if you want to go deeper on any of the specific topics we mentioned today, our podcast also has a series called Listen and Learn. Those episodes take one specific legal concept, review the rules in more detail, and apply the law to a fact pattern. We'll link to the relevant Listen and Learn episodes in the show notes for this episode, so you can pull up the ones that interest you whenever you're ready. Today, we're talking about torts. Torts is a huge subject, so we're going to do two things in this episode. First, we'll spend a few minutes orienting you to what torts are in general, and we'll briefly name the main intentional torts. Then we'll spend most of our time on negligence, which is going to be the heart of the torts class and the bulk of your final exam. We'll walk through the four elements of a negligence claim, and then we'll apply them to a short fact pattern at the end. If you're listening to this before law school starts, don't worry about memorizing everything you hear. Just let it wash over you. The goal is recognition so that when your professor uses these terms in class, you've heard them before. And with that, let's dive in. So what is a tort? In plain English, a tort is a civil wrong. Someone does something or fails to do something that injures another person, and the injured person can sue for money damages. The word tort comes from the Latin for twisted or wrong. In law school, you'll just learn it as the name of an entire body of law. It's important to understand how torts differ from crimes. When someone commits a crime, the state prosecutes the wrongdoer, and the punishment is usually jail time or a fine paid to the government. When somebody commits a tort, the injured person, not the state, brings the lawsuit, and the remedy is usually money damages paid to the victim. The injured person is called the plaintiff. The person being sued is called the defendant. You'll see those two words on every page of your torts casebook, so get comfortable with them now. A single act can be both a crime and a tort. If a drunk driver runs a red light and crashes into another car, that's the crime of driving under the influence, prosecuted by the state. And it's also the tort of negligence, where the injured driver sues for medical bills and car repairs. Same conduct, two different systems running on parallel tracks. Tort law is generally divided into three big categories: intentional torts, negligence, and strict liability. We're going to spend a few minutes on intentional torts, and then we'll spend most of our time on negligence. Strict liability, which covers things like injuries from defective products, attacks by wild animals, and abnormally dangerous activities, we'll save for another episode. So let's start with intentional torts. The defining feature of an intentional tort is, you guessed it, intent. Intent means the defendant either acted with the purpose of causing a particular result, or the defendant knew with substantial certainty that the result would happen. So if I throw a rock at someone wanting to hit them, that's intent. But intent also covers cases where I don't necessarily want the result, but I knew it was almost certainly going to happen. If I throw a rock into a crowded room, I may not have wanted to hit anyone specific, but I knew with substantial certainty that I'd hit someone. That's intent too. There are several intentional torts you'll learn about during your torts class. I'm just going to name them briefly so you'll have labels in your head. We're not going to dive into the elements of each one. Your torts professor will do that, and we'll link to Listen and Learn episodes on most of them in the show notes. So first, battery. That's a harmful or offensive contact with another person. Punching someone is a battery. Spitting on someone is a battery. The contact doesn't have to be painful, just offensive to a reasonable person. Second, assault. In tort law, assault is different from how the word gets used in everyday speech, and from how it's often used in criminal law, too. People usually use assault to mean hitting someone, and some criminal statutes include the actual contact. But tort assault is about apprehension, not contact. It's when the defendant causes the plaintiff to reasonably apprehend an imminent harmful or offensive contact. So swinging a fist at someone and missing, but they saw it coming, is an assault, even though there was no actual contact. Third, false imprisonment. That's intentionally confining someone to a bounded area against their will, where the person is aware of the confinement or harmed by it. Fourth, intentional infliction of emotional distress, often abbreviated as IIED. That's when the defendant engages in extreme and outrageous conduct that intentionally or recklessly causes severe emotional distress. Fifth, defamation. That's a false statement of fact about another person communicated to someone else that harms the person's reputation. The two main forms are libel, written defamation, and slander, spoken defamation. Then there are the property-based intentional torts. Trespass to land is the intentional entry into someone else's personal property. Trespass to chattels and conversion both involve interference with someone else's personal property. Chattels is the formal legal term for personal property like a car or a watch. Conversion is the more serious version where the interference is so substantial that the defendant essentially has to pay for the full value of the item. So that's 8 intentional torts in less than 2 minutes. And I know that's fast. Don't try to memorize the elements right now. Just notice that intentional torts share a common feature. The defendant did something on purpose, or at least knew the result was substantially certain. Hold that in your mind because it's about to contrast sharply with what we look at next. Now let's turn to negligence. Negligence is not about intent. Negligence is about carelessness. The defendant didn't mean to hurt anyone. They just failed to be careful enough, and someone got hurt as a result. Negligence is by far the most heavily tested topic in 1L torts, and it's going to dominate your final exam, so this is the part to really pay attention to. To win a negligence claim, the plaintiff has to prove 4 elements. Your professor in your casebook will call this the prima facie case of negligence. That phrase just means the basic case the plaintiff has to make. The 4 elements are duty, breach, causation, and damages. Say them with me this one more time. Duty, breach, causation, damages. Those 4 words are the backbone of your entire torts class. Almost every essay question you see, almost every hypothetical your professor puts on the board, you'll work through these 4 elements in order. Think of it like a chain with 4 links. If any one link breaks, the whole chain fails and the plaintiff loses. So the defendant only has to defeat one element to win. The plaintiff has to prove all 4. So let's walk through them. Element 1, duty. The general rule is that everyone owes a duty to act as a reasonable person under the circumstances to avoid causing foreseeable harm to others. So when you get behind the wheel of a car, you owe a duty to other drivers, pedestrians, and bicyclists to drive carefully. When you own a store, you owe a duty to your customers to keep the premises safe. When you walk down the sidewalk carrying a hot coffee, you owe a duty to the people around you not to spill it on them. The standard we measure conduct against is called the reasonable person. The reasonable person is an objective standard. The question is not whether this particular defendant was doing their best. The question is what an ordinary, prudent, reasonably careful person would have done in the same circumstances. Now, there are some special duty rules you'll want to learn about. Professionals like doctors and lawyers are held to the standard of a reasonable professional in their field, a specialized standard that reflects the training and skill expected of someone in that profession, rather than what an ordinary person would do. Children are usually held to the standard of a reasonable child of similar age, intelligence, and experience, unless the child is doing an inherently adult activity like driving a car. Landowners owe different duties depending on who is on their land. There are different rules for invitees, licensees, and trespassers. We have full listen and learn episodes on each of these special duty rules linked to in the show notes. For now, just know they exist. Element 2 is breach. Breach simply means that the defendant failed to meet the duty of care. They didn't act like a reasonable person would have. To analyze breach, you compare what the defendant actually did to what a reasonable person would have done in the same situation. Sometimes breach is obvious. A driver going 70 miles per hour through a school zone has clearly breached the duty of care. Other times, it's a closer call, and you'll have to argue both sides. On a law school exam, your professor will reward you for considering arguments on both sides of a breach question. If the facts could support a finding of breach, but also support a finding of no breach, argue them both, and then say which is stronger and why. There are also a couple of shortcut routes to proving breach that you'll hear later in the semester. One is called negligence per se. That's when the defendant violated a safety statute, and two things have to line up. The plaintiff has to be in the class of people the statute was designed to protect, and the injury has to be the type of harm that the statute was designed to prevent. If both fit, the statutory violation establishes breach. The other is called res ipsa loquitur, which is Latin for the thing speaks for itself. That doctrine lets the plaintiff prove breach by showing that the accident is the kind of thing that doesn't usually happen without negligence, like a barrel falling out of a second-story window. Don't worry about the details now. Just know these are two named ways to establish breach that you'll see again. Element 3 is causation. Causation is where things get a little tricky because there are actually two parts to it: actual cause and proximate cause. The plaintiff has to prove both. Actual cause is also called cause in fact, or but-for causation. The test is straightforward, but for the defendant's negligent conduct, would the plaintiff's injury have occurred? If the answer is no, the injury would not have happened without the defendant's conduct, then actual cause is satisfied. If the answer is yes, the injury would have happened anyway, then there's no actual cause and the plaintiff loses. So here's a quick example. A driver runs a red light and hits a pedestrian. But for the driver running the red light, would the pedestrian have been hit? No, so actual cause is satisfied. Proximate cause, sometimes called legal cause, is harder to pin down. Even if the defendant's conduct actually caused the harm, the law won't always hold the defendant responsible if the harm is too distant, too unforeseeable, or too freakish. Proximate cause is essentially a policy filter. It asks, is it fair to hold this defendant responsible for this particular harm? The touchstone of proximate cause is foreseeability. If the type of harm that occurred was a foreseeable result of the defendant's negligence, proximate cause is usually satisfied. If the harm was bizarre or unpredictable, proximate cause may be lacking. There's a very famous case you'll read in your first few weeks of torts called Palsgraf versus Long Island Railroad, which is the foundational case on proximate cause. I won't spoil the facts for you because reading Palsgraf is a rite of passage for everyone else. Just know that when your professor starts talking about Palsgraf, they're talking about proximate cause. Element 4, damages. To win a negligence case, the plaintiff has to show actual harm. This is one of the key differences between negligence and some of the intentional torts. With certain intentional torts, like trespass to land, the plaintiff can sometimes win even without any real injury. With negligence, no harm means no claim. The plaintiff has to have suffered a physical injury, property damage, or in certain narrow circumstances, severe emotional distress. Damages come in several forms. There are economic damages, like medical bills, lost wages, and the cost of repair to damaged property. There are non-economic damages, like pain and suffering. And in rare cases involving really egregious conduct, there can be punitive damages, money awarded not to compensate the plaintiff, but to punish the defendant. Okay, that's the 4 elements: duty, breach, causation, and damages. Hopefully you're still with me. I know we covered a lot of ground there, so let's bring it together by walking through a short fact pattern. As I read this hypo, listen for where each of the 4 elements shows up. Try to spot them in real time. Then we'll work through this analysis together. Here's the fact pattern. Maria is shopping at Fresh Mart on a rainy Tuesday afternoon. About 30 minutes before Maria arrives, another customer drops a glass bottle of cooking oil in aisle 5, and the bottle shatters. A Fresh Mart employee named Tom sees the spill, places a single small "Caution, wet floor" sign about 8 feet away from the actual spill, and then walks off to find a mop. Tom gets distracted, helping another customer at the register, and never returns to clean up the oil. 25 minutes later, Maria turns into aisle 5, reading a shopping list, doesn't see the spill, slips on the oil, and falls hard onto the tile floor. She fractures her wrist, requires surgery, misses 3 weeks of work, and incurs $40,000 in medical bills. Maria sues Fresh Mart for negligence. Let's go through the 4 elements one at a time. First, duty. Did Fresh Mart owe Maria a duty of care? Yes. Stores owe a duty to their customers, people invited onto the property for the business's benefit, to act reasonably to keep the premises safe. Maria was a paying customer shopping in the store. She is owed a duty of care. Element 1 is satisfied. Second, breach. Did Freshmart breach that duty? Well, this is where we compare what Freshmart did to what a reasonable store would have done in the same circumstances. The store knew about the spill. Tom saw it. So this isn't a case where the danger was hidden. The store had actual notice. Tom put up one small warning sign, but 8 feet away from the actual hazard, and then left. He never came back. The spill sat unattended for 25 minutes. A reasonable store, knowing about a slippery spill on the floor, would either clean it promptly or post adequate warnings directly at the hazard. Freshmart did neither. That looks like a breach. On an exam, you'd want to argue both sides. A defense lawyer might say that putting up some kind of sign was reasonable. But on these facts, sign too far away, employee never returned, 25 minutes elapsed. The better argument is that there was a breach. Element 2 is satisfied. Third, causation. Remember, causation has 2 parts. Actual cause first. But for Freshmart's negligent conduct, leaving the spill unattended without an adequate warning, would Maria have fallen and broken her wrist? No. If Tom had mopped it up, no slip. If there had been a clear sign right at the hazard, Maria likely steers around it. So but for causation is satisfied. Now, proximate cause. Was Maria's injury a foreseeable result of leaving a slippery spill unattended? Well, absolutely. That is exactly the type of harm the duty is designed to prevent. Customers slipping and getting hurt. Nothing freakish or unforeseeable about it. Proximate cause is satisfied. Element 3 is satisfied. Fourth, damages. Maria suffered a physical injury, a fractured wrist requiring surgery. She has economic damages, $40,000 in medical bills, and 3 weeks of lost wages. She likely has non-economic damages too in the form of pain and suffering. Element 4 is clearly satisfied. So all 4 elements of negligence are met. Maria has a strong negligence claim against Freshmart. Now, in a real case, Freshmart might raise defenses. Things like comparative negligence, where they'd argue Maria was partially at fault for not watching where she was walking. We'll cover defenses in a future episode. For now, what I want you to take away is the 4-element framework and the discipline of walking through each element in order. So that is the basic structure of every negligence question you will ever see on a 1L exam, on the bar exam, in real life as a lawyer. Duty, breach, causation, and damages. Walk through them one at a time. Apply the facts to each. State your conclusion on each element before moving on to the next. Don't skip ahead. Don't lump them together, and don't forget any of them. Before we wrap up, a quick recap. Torts is the body of civil law that lets injured people sue for money damages. The 3 big categories are intentional torts, negligence, and strict liability. Intentional torts include battery, assault, false imprisonment, IIED, defamation, and the property torts. They all involve the defendant acting on purpose. Negligence is about carelessness, and it has 4 elements: duty, breach, causation, and damages. Strict liability is for a future episode. If you want to go deeper on any of the topics from today, check out the show notes, and we'll link to our Listen and Learn episodes on the reasonable person standard, negligence per se, proximate cause, factual causation, the duties of landowners, the breach element, several of the intentional torts, and more. They go into more depth than we did here, and they're a great next step once you're in your torts class. Next time in the Law Everyone Else Should Know series, we'll tackle another core 1L subject. Until then, take a breath. Law school is going to throw a lot at you, but if you have the frameworks in place before you start, you'll be ahead of the curve. Thanks again to Juno for supporting this podcast. If you're thinking about student loans for law school, head to joinjuno.com to explore your options and see how Juno can help you find a better rate. Thank you so much for watching. Please be sure to give us a like, leave us a comment, and subscribe so you don't miss any future content. If you'd like to learn more about what we do, check out lawschooltoolbox.com.